Ladies and gentlemen, welcome to another episode of Legally Speaking. I'm your host, Oves Anwar. The law serves multiple functions, and one of those is signaling, whether it is through legislation or judicial verdicts. Your political leadership or your judicial leadership can help shape society, and it does so by establishing standards. And then it requires you and I to meet those standards. And if we don't, the law becomes coercive. It can impose penalties, and it can punish people who deviate from what is the norm that they have set. And no one can really opt out of this. You can't suddenly say, I don't like this law and I don't want it to apply to me. You can't say, I don't like going to court. If you're called, you have to be there. And it's really this element of coercion that can make the law a tool of oppression. In the context of women and their enjoyment of their fundamental rights under the Constitution, we have seen time and time again the law being used as a tool of oppression and perpetuating patriarchal norms and attitudes. Today, I want to explore how the law impacts women, especially in cases of sexual violence, how they go through the legal system, how the law applies to them, how it applies differently to them, and what can be done and what is being done to change the law. For this, I'm joined by Ms. Sahar Bandial. Sahar is an advocate of the High Court and a member of the Adjunct Faculty of LUMS University. Thank you so much for joining us, Sahar.
Thank you. Thank you, Wes, for having me.
Brilliant. Sahar, you've been part of landmark judgments. You've seen really how the law has evolved, certainly over the past decade or two. When we talk about the law being used to subjugate or the law being an oppressive tool, what do we really mean by that?
Essentially, and as you stated, the law is a coercive instrument of the state, right? And it's also a signifier of what the state considers right and wrong. The law becomes a tool for subjugation and oppression of women when the lettered law itself is flawed. Number one, let me give you examples, and I come to another aspect of how then the law becomes an instrument for injustice. We have various examples in the Pakistan legal system where the lettered law itself is discriminatory against women. There are clear and stark differences how it treats men as opposed to how it treats women. And this sort of problem persists despite various constitutional guarantees that exist in our constitution on the equality between genders and the right to non-discrimination and other international obligations that Pakistan has signed into. One example, very obviously, is the Qisas and Diyat laws. Now, you do know that there's a huge problem of honor killings in Pakistan, and mostly women are the victims of honor killing. In 2024, there are about over 400 reported cases of honor killing. The actual number may, in fact, be much more. What the Qisas and Diyat laws do then is that they privatize the murder of women who are killed in the name of honor and grant family members the right to forgive perpetrators who have murdered their daughters, sisters, whatever, in the name of honor. Oftentimes, those perpetrators are family members themselves. So it becomes an entirely private affair. The state steps back and lets murder, very horrific murder, many times, to be compounded and forgiven, creating impunity for such kind of horrific violence against women. There have been attempts to reform the law. In 2016 was the latest kind of attempt to amend Section 311 of the Pakistan Penal Code to sort of close this loop of forgiveness or loop of or the space for impunity. Doesn't really work. It's still in the discretion of the judge whether or not they allow family members to forgive and compound honor killings. Second example, where the law is very obviously discriminatory against women, are your evidence laws. So when it comes to financial transactions or written contracts, the testimony or the standing of a woman as a attesting witness is half that of a man. So what happens actually in practice is that the legal system ends up questioning the competence of a woman to be a witness in many such transactions. You go to a bank, they will not accept a document that is witnessed by a woman. I mean, I've done a bit of banking litigation. You'll see probably all are witnessed by men. Hardly any women. The women might be the executants of those documents, but they're never witnesses. Very stark, obvious difference, signifying to the society, to to law enforcement agencies then women are probably not reliable witnesses. They will forget, they won't recall what they've signed on to.
Yes.
Third example, are your marriage laws. So apart till yesterday, actually, I just learned yesterday there's an ordinance passed by the government of Punjab where the age of marriage for men and women has been aligned. It's now 18
Yeah.
in both. But for the longest time, the minimum age for marriage for women was 16, for men was 18, creating this differential in how young boys and girls are treated, creating the likelihood that a lot of more younger women will be or girls will be forced into child marriages, sort of taking away the right to education, personal growth, etc. Citizenship laws is another example. So, Pakistani man marries a foreign woman. That foreign woman becomes entitled to Pakistani citizenship upon registration of domicile or domicile certificate. Not the same case for Pakistani women. That doesn't happen. If a Pakistani woman marries a foreign national, that sort of entitlement to nationality for her husband does not automatically arise. I think in 2024, 2025, I forget exactly when, but the Sindh High Court held that that differential in treatment between Pakistani women who marry foreign nationals and Pakistani men who marry foreign nationals is discriminatory and unconstitutional, but the law has not changed since then. So these are various examples of how the lettered law in itself is very obviously differentiating between men and women and signifying to the society, to people around us, that women probably do not have the same value or standing or rights that men do. The second way that the law becomes an instrument of oppression is when it is not properly implemented. As you stated, the last 2 decades are very significant in that there has been so much legislation, pro women legislation, on a
Yeah.
range of subjects, economic, violence related, etc. Let's look at the domestic violence law. Now, under the domestic violence law, I'm talking about Punjab now. We have domestic violence laws in ICT and then the four provinces, all
Mhm.
four provinces. But in Punjab, domestic violence includes sexual violence, economic abuse, psychological violence, etc. The special court designated under this act is meant or has the standing to give an interim protection order as soon as a woman approaches the court with her complaint and says that I have been a victim of domestic violence. What is happening in practice? What happens in practice is a woman who has been beaten up goes to court, and the court first says, let me issue notice, let me hear the other side, does not give a protection order, does not give any prohibition order, and the woman is forced to go back to the same abusive environment that she came from. Second, there are many reported incidents where the judges of these courts are in fact trying to bring about a reconciliation between the parties. Instead of hearing the woman out and becoming a means of giving her some sort of redress, they become some sort of conciliators in the marriage. So law not being enforced as per its purpose, and in
Yeah.
fact turning against the survivor or the victim who approaches them and sending them back to abusive and violent environments. We see this sort of misinterpretation or misapplication of the law happening all the time in cases involving sexual violence. Now, I know we may discuss this later on in our conversation today, but it's clearly providing the law that the past sexual history of a survivor of sexual violence is completely irrelevant to the question of whether the violent crime occurred or not. But reports indicate that at the level of the trial court, the judges continue to allow a line of questioning by the defense to discredit the victim or the survivor by questioning her character and raising questions regarding her past sexual history. The police do the same. The police will, if you talk to them about rape cases, they will turn around and say, oh, most of them are false. Instead of registering complaint, they categorize
Absolutely.
complainants as complainants who can be relied upon and who cannot be relied upon. So it's a problem that persists across the criminal justice system, the police, medical legal examination, and on to the trial court judges. There is
Absolutely.
Sorry, go ahead.
So, no, Sahar, I mean, I completely understand where, I mean, there have been instances where, I've been in trainings and the entire, the entire group of participants before me would all say that, the vast majority of these cases are false, or I haven't come across an honest a complaint. Is that, an admission of failure that our system is so broken that we can't even bring complaints or genuine complaints, or is that simply, individuals who are, so engrossed in a system, so entangled in a system that they can't even consider that, genuine complaints in Pakistani society can take place?
Um, Awais, I agree that there's a general culture of disbelief against women who approach the legal system with such sort of complaints of sexual violence. I am not going to say that the opinion of all these people that you have also interacted, and so have I, is completely incorrect. They may have come across false cases and fake cases, but it cannot be the case that every complaint that comes before the police officer is false. And that is the kind of attitude they proceed with when they're registering complaints, when they are sort of investigating, and when the matter goes up all the way to a trial. I mean, I believe that this sort of disbelief, this culture of disbelief, also exists amongst medical legal officers. And in a
Yeah.
very recent conversation that I had with someone who is, a professor of forensic science at a particular place in Pakistan, um, and I asked her about her role and the role of medical legal officers in the exercise of medical legal examination. And her response was that we can tell which woman is lying and which woman is telling the truth. Now, that is not the role of a medical legal officer. It is not their role to sift out the truth or the untruth or lies. Their role is to make observations regarding the physiological state of the woman, any injury seen, any sort of medical samples that may be taken. But this idea that from the very beginning, from the very initiation of the complaint, the truth or the falsity of complaints can be sifted out is, I think, very problematic, and it then has a chilling effect on genuine cases of sexual violence that may occur, because it discourages victims from coming forward, because if they are going to be treated with suspicion from the get-go, how will they survive through years? It takes probably over, there was a recent report that it takes maybe over a year and a half or 2 years to conclude a trial. How will they power through all that time when the entire system is kind of questioning their credibility through this process?
That's the so that brings me to a question. I mean, we have, as we just discussed, the system is so inherently hostile to women who want to bring about complaints that even genuine complaints could be discouraged like that. Do you think this is a failure in the language of the statute? I mean, is this the legal procedure that is the issue, or is this when the black letter of the law hits humans applying the law, right? People applying the law and the government, and it's that culture that comes.
Avais, I want to compliment the state that in the last 15 to 20 years there has been a lot of effort at pro-women legislation. And the
Mhm.
black letter law is obviously where we start with. That's our starting point. And we have very positive changes, especially that came, we're talking about rape, so coming back to that, very positive changes that were made in the Criminal Procedure Code and the Penal Code in 2016, then again in 2021, where procedural protections have been provided to survivors, where it's been clarified that, consent in sexual violence cases must be unequivocal and communicated very obviously through words or through actions. Various changes. Don't want to get into all of them, but when it comes to implementation, as you said, the law is not divorced from the society that we're operating in. And then from the very first point of contact, from the police, medical legal, trial court judges up to the appellate level, you have human actors implementing the black lettered law. And that implementation obviously is informed by their expectations of what is appropriate gendered behavior and what is not. Who is a woman who is entitled or worthy of the protection of the state, and which woman is not? So those notions then come in, very paternalistic and oftentimes very patriarchal notions then come in the interpretation of a law which is otherwise very innocuous, very neutral in its language.
Absolutely. I think class also plays a huge issue in this, where
Yes,
all
yes.
this entire milieu, religion, so many elements are there. Um,
Class, race, religion, ethnicity, all those factors, all those intersectionalities then come into play to give law the face that it eventually takes.
Absolutely, absolutely. Um, so we've also come from a history where we've seen, the Hudood Ordinances, the Zina framework, really being weaponized against, for personal enmity cases and for things like that. Have we come out of that? Have we, moved past that particular legacy, or is that still, tainting how things operate in Pakistan?
So the Hudood Ordinance, and I think a lot of us who are familiar with legal history of this country know that it sort of evolved into this horrible monster that came to be applied against women. The provision in the law, in the Hudood, the Zina Ordinance particularly, was that in order to establish a case of zina, adultery, or zina bil jabr, which is rape, you either needed the testimony of four male eyewitnesses that met a particular criteria of good character, or upon the confession of the accused. What happened in the implementation of this law was that when a woman came forward with a complaint of zina bil jabr and was unable to prove the act through that four male eyewitness testimony, her complaint would be treated as a confession that she engaged in illicit intercourse, and that then would be a ground for prosecuting her for adultery. So the complainant would become the accused. The law
Yeah.
would turn against the person who approached the law for protection. That is what was happening under the Zina Ordinance, and it took about 2.5 decades of a lot of activism and pushing by women's rights activists, lawyers, even political parties to eventually get that bit in the Zina Ordinance repealed. So rape, which was Zina bil Jabr, was removed from the Hudood Ordinances and put back in the Penal Code in 2006. And then the idea was, the hope was that this sort of um, shifting of blame and transformation of the victim to the accused, as was happening in the Hudood Ordinance, would no longer occur. But now, in 2025, what we see is that the apex court, your most superior court in this country, Supreme Court, is doing exactly that. So, in a
Wow.
complaint that comes before, and at the appellate stage, the Supreme Court, where the complaint of rape, the accused has been convicted at the level of the High Court, trial court, etc. And the Supreme Court finds that there is no sufficient evidence to uphold the conviction of rape. What they do is that they convert that conviction into one of fornication, which is of consensual relations. So just want to flag it out that the offense of rape is sort of premised on the idea that it is non-consensual relations. Adultery, fornication is illicit consensual relations. So, what the Supreme Court does in these judgments that came out, one last year and the one year before in 2024, is that they convert the conviction of consensual relations to one of, sorry, non consensual relations to one of consensual relations, rape to fornication, opening up the possibility that the woman who came to the law to complain of forceful intercourse, rape, can now be prosecuted for having illicit intercourse, that is, for fornication. She again becomes potentially an accused. And although they don't convict the complainant in either of these cases, they do recognize, the Supreme Court does recognize in both these judgments that yes, we've converted the conviction, and yes, we agree that this conviction now can open up the possibility of prosecuting the complainant as well. And then they completely sort of muddle up the whole requirement understanding of these two very different offenses. Like one is non-consensual, one is consensual. And by muddling them up, the court is essentially imputing consent. The victim is saying, I did not consent. But the court is turned around and saying, oh, yes, we think you consented. Therefore, we are changing the conviction. So this conversion and this sort of disbelief in the victim's statement that the act was non-consensual is
Yeah,
essentially a disbelief in the woman. Again,
absolutely.
the same culture of disbelief that we are talking about. That we don't believe that you did not consent. We think you consented. On what basis? There is no evidence, and that is what one of the critiques that has been forwarded about these judgments is that the court has presumed consent without actually there being any leading evidence on the fact that the act was consensual.
Absolutely. And Sahar, I think one of the I mean, it's baffling to see how you get the worst possible outcomes from the decision. Is it something to do with this perverse obsession with, say, women's sexual histories, or is this just the ultimate form of victim blaming, that where you have the legal system itself, the judicial system itself, telling a woman that when you complain for sexual violence, no, we will now convert this into a consensual form, and hold you accountable for having even complained really about this.
I think the problem is that we don't understand what is consent. And the problem is that the legal system has developed its own standards of how they will define whether there was consent or not. So despite there being judgments to the contrary, trial courts and even higher courts will continue to look for marks of violence to establish consent, whether there was any hue and cry, etc. So they are operating on a very sort of typical standard or of how they expect that a woman will respond in such cases. But
Mhm.
a lot of feminist writing and jurisprudence internationally indicates that women do not react in an atypical way to situations where they are subjected to sexual violence. Some will freeze, some will run, some will scream. And this nuanced understanding of women's reactions probably has not made its way to the judicial mindset or judicial imagination, because judicial imagination is a very male imagination. It is a very male understanding of how men expect women will react in such situations. Until that nuance emerges in an understanding of women's psyche, women's reactions, I think there will continue to be reliance on these very old school, traditional tools through which consent or non-consent is then gauged.
Yeah.
I wouldn't go on to say that the entire system is just directed towards victim blaming, because I do think that there have been a lot of positive changes and judgments that have also come out, where there's an appreciation of such nuance, where there's an appreciation of what we call the gendered perspective. But when you are, or when the judiciary or the legal system continues to operate in a very male centric paradigm without understanding these nuances of gendered behavior, we will continue to sort of see these problems in our system.
So, excuse me. I want to come back to the issue of victim blaming, certainly, but you've been you filed a petition against the two-finger virginity test. Um, can you tell me how or why a test that had no forensic value, that had really very little that it could add to that, and was a humiliating, demeaning test for women, how it survived this long, and why it took this long to really rectify?
You know, what's interesting is that, and there's something I learned when we were preparing for this petition, that this test has no legal basis. There is no legal or no law in which this test was grounded. And in fact, it emerges through practice in reliance on what we call Modi's text on medical jurisprudence and toxology, the first edition published in 1920. So any justification for use of this test then goes back and refers to Modi's text. And this is not that Modi we're
I
talking
know.
about. There's another Modi. So,
Yeah. I doubt he has a
um,
medical degree. So,
so it relies on that textbook, not law, textbook. And it sort of got intertwined in our system because in the medical legal examination of survivors, this test was being used. And then those medical legal reports would make conclusions regarding the victim's sexual history, and they would say something to the effect, I'm paraphrasing, of course, the test is positive, victim appears habituated to sex, or test is positive, victim is a woman of easy virtue. Language used in the reports, language picked up from the reports, and then replicated in judgments. And I sort of wrote this down because I thought it would be interesting to see how judgments would sort of refer to this test. So this is a judgment from 2008, Pakistan. Victim appears to be a woman of easy virtue, indulged in sexual activities, and her sole statement cannot be relied upon in the absence of strong corroboration. So this language over the years found its way in judicial decisions, and then it just became part of precedent. A
Wow.
test that had no legal basis got adopted in our judicial decisions and continued to be used for decades. In
Mm-hmm.
2013, it was declared to be unlawful in India. In 2018, Bangladesh High Court also banned it. And then we banned it, Pakistan banned it in 2021 by through the Lahore High Court judgment of Justice Aisha Malik. And interestingly, the Modi's text, which was often referred to justify this test, now also clarify that this test has no real value and is a distressing practice. I think that's the kind of language the text now uses. So it's interesting to note that
Absolutely.
this
No,
really
that's
had no legal basis, yet became such a tool to oppress and discredit women.
absolutely. And I think one of the biggest issues we see in the criminal justice around Pakistan is that you'll have a particular culture that develops, and then that culture perpetuates for decades, right?
Yes.
And we've seen this in so many instances here. Um, I wanted to ask you, what do you feel that since, well, I mean, the past decade or so, we have seen progress, right? And you've mentioned that as well, especially since the two-finger test judgment, and how do you feel has been the impact of that particular judgment, and what are the attitudes? Do you see a more positive attitude towards, say, women who complain about sexual violence, or generally the law dealing with women and the legal system dealing with women?
I think the very immediate effect of the judgment is that the law now rejects categories of a rapeable woman and a non-rapeable woman, which woman is, as I was saying earlier, entitled to
Yeah.
protection of the law, and which is not, and who is not. And just Aisha Malik in the judgment very clearly says that the law is equally to protect promiscuous women. It does not matter if a promiscuous woman has any sexual history. There is no relevance on the question of whether she consented or not to a particular sexual act. That is the immediate, very immediate impact. In terms of this judgment being implemented in its true letter and spirit, there are reports that indicate that the medical legal exam is largely not being used during medical examination of survivors and victims of sexual violence.
Mhm.
Whether this judgment has completely sort of put a stop to the practice of bringing in the sexual history of a survivor to discredit her testimony, I think the short answer is probably not. The police continue to do it, medical legal officers continue to do it, refer to sort of bring in any sort of impression that they have about the character or the sexuality of the woman, sexual history of the woman to discredit her. Continues to happen in trial court. As I stated earlier, courts are not putting an end to sort of cross-examination that goes down this road where the victim is questioned on account of her character or sexual history. So I think it's a kind of a mixed bag. The law has redirected towards into a more positive direction, and then this judgment was again, the principle was again in it was again reiterated by the Supreme Court in a later judgment. We saw that there's been reform in the definition of rape, which clarifies what consent is, and then terms sexual history in many ways as irrelevant. But in terms of how it's being implemented at the trial court level, I think it's not being done so in its true letter and spirit. It's going to take
I
a long
see.
time because, like you said, these are human actors with their prejudices, with their ideas, and although we now have something to rely on to redirect their thoughts and ideas and perceptions, but I think it's still a long way to go.
No, absolutely. So coming back to the issue of perhaps the victim blaming. We just saw the end to the Noor Mukadam case, and the entire saga. It was a high profile case. The whole country was following it. Finally, Noor's family and the nation have some much needed closure to this. The Supreme Court upheld the death penalty, but they upheld this for murder, and they reduced apparently the death penalty for rape. What do you think this means? What do you think the judgment really means for women and women seeking protection through the law?
So what's interesting is that the High Court in appeal increased the penalty from 25 years for rape to then the death penalty. And this, I think they did so because of Section 376 1A, which refers to rape with injury. So where there's commission of rape and the victim suffers serious injury, as defined in the hurt offenses in the Pakistan Penal Code, the maximum penalty is death. And keeping in account the violence suffered by Noor Mukadam, in addition to the rape committed on her or against her, the High Court enhanced that penalty. But when you come and read come to Supreme Court level and read the Supreme Court judgment, there is no indication on why they are reducing the penalty. I think most of the judgment focuses on the judgment of Justice Kakar focuses on the admissibility of CCTV footage and electronic and digital evidence. And towards the end of the judgment, the sentence is reduced. No explanation apart from preceding paragraph where the judgment quotes that the victim and the accused were good friends or close friends. And that's it. No indication on why they think the sentencing should not be under 376 1A, which is an aggravated form of rape, and why should then they revert back to a lower sentence of life. I think that the preceding paragraph before the final sentence is announced is indicative of the thought process that the court had in mind. The fact that the victim was known to the accused, Noor Mukadam was known to the accused, or they had a prior relationship, may have played a role in reduction of the sentence. It's not clear from the judgment, but that is where what I think may have been the justification for doing so. And the additional note that came out last year, later last year, kind of confirms my understanding of why the sentence was reduced. And I think we are all aware of that last paragraph of the judgment. And I'll sort of read it out again.
Relationship. Yeah, please.
I also observe that the present case is a direct result of a vice spreading in our society, and then goes on to describe the case as a case of a living relationship, and the young generation must note its horrible consequences.
Wow.
So, towards the end, when justifying the sentence for murder, the additional note then sort of doesn't discuss why the sentence for rape was reduced, but goes on to conclude with this very important message, where this horrible murder and sexual violence is explained or taken as an example of something that happens when there is a living relationship, thereby implicating the victim indirectly for having engaged in such a relationship, if it was one. I mean, I don't want to comment on it. If it was one, blaming the victim for having that kind of relationship with the accused who butchered her to death. So again, we see some sort of victim blaming happening in a very horrific and clear case of murder and sexual violence. It's something akin to saying, this has happened, it's very horrible, we're going to sentence the accused, but let us warn you that these kind of things happen when women behave in a particular way. That's the kind of messaging given. And that is a general cultural understanding of it. I think it's not just that this doesn't come as a surprise to me. That's what I'm trying to say. This is this is what a lot of men and women in our society continue to believe and think. You sit in a social setting and you ask anyone about this case when it was during the trial stages, many people would come up with this reaction. Yes, horrible, but dot dot dot. And eventually it's a problem of mindset. The law does not provide that such sort of conclusion should be given. The law for aggravated rape with injury is very clear regarding the sentence. But that sentence was reversed, and we don't know why. We can conjecture that this is the reason why the Supreme Court did not think it fit to award the death penalty, even though Section 376 1A gave it the right to do so.
What's clear than, rape and murder in proving that? Um, Sahar, this really, brings me to the point that for the first time, perhaps not for the first time, but certainly was really eye-opening that victim blaming became such a big issue. And when we put it into words in a judgment or in an additional note as well, does this not dilute the message that the state is trying to send? That when we are, as a state, as a polity coming together and saying, we denounce rape, we denounce sexual violence, but then you come up with, but, you need to do this, all of those things. Does it not dilute that message and then almost justify it in the extreme at times?
It definitely dilutes the message. And I think, I wouldn't say justify, but they try to explain it. They give it an explainability. It happened because the woman reacted this way. That is the message. It places an onus on women to behave a particular way so they don't put themselves out to be
Mhm.
harassed, killed, raped.
Yeah,
And I mean, I do some work on sexual harassment at the workplace, and it's so interesting to see that in cross-examination, that's the first question that's asked. What were you wearing? If you were wearing an abaya, why would somebody harass you? Why were you out at 11 p.m. at night? And we saw this in the motorway rape case, if you recall, a couple of
absolutely.
years ago.
You shouldn't be driving this
Horrific
late at
incident.
night. Yeah.
Yeah, you shouldn't be driving this late at night. Where was your husband? Why was there no petrol in your car?
Mm.
All these questions regarding the woman's character came up when this and the highest state level. You have a very senior state official saying this at a press conference, in fact. So yes, all of this is horrible. We are making all these laws to protect women, but the messaging is that women are equally responsible for inviting violence against themselves. That's the kind of messaging that is given. So, violence against women is then explained away by reference to women's conduct or to women's behavior. I wouldn't say
Absolutely.
justified, but
Mhm.
explained away. And then that dilutes the criminality and culpability of the person, of the accused, and also dilutes the responsibility of the state. If the state is telling me that I should not behave in a particular way if I want to be safe, then the state is diluting its responsibility to take measures to protect me.
And I also feel that the statements like these, or when attitudes persist, it's that the aberration in acting was the woman's fault, right? It isn't that
Hmm.
the person who committed the sexual violence really is the aberration in normal behavior. And I think that is something that also brings in. And we also, I mean, I wanted to very
Vince,
quickly,
I want to
yeah,
add here that, feminist theories and writings clarify that all forms of gender-based violence have less to do with desire and more to do with power.
yeah,
So, rape is an offense of power as opposed to an offense of desire. Same for sexual harassment. So, in patriarchal societies where this power differential is so obvious and strong, gender-based violence will manifest itself because of this power differential. And what's interesting, and this I am so appreciative of, that a lot of our Supreme Court judgments are giving this understanding and definition to gender-based violence as crimes of power and patriarchy as opposed to crimes of desire. um, I think that's an important formulation that is now being developed and accepted, and I hope it further grows and sort of penetrates our system across the board.
Absolutely. Sahar, thank you so much. This has been wonderful. It's really helped us better understand, some of the dynamics between the Supreme Court judgments and what's really happening in terms of sexual violence cases in Pakistan. Thank you so much.
Thank you, Wes, and thank you for raising these very important issues.
Ladies and gentlemen, that brings us to an end to this episode of Legally Speaking. If you've been watching this on television, this was a shortened version of our discussion. And you can watch the full entire podcast on DawnNews English's YouTube channel, where we go into deeper arguments, the context, looking at various other questions surrounding the issue of women's rights and how the law applies to them. Thank you again for watching. I'm Oves Anwar, and I'll see you next time, where we'll once again be legally speaking.